Almost there.
Yeah.
And live we go.
Thank you.
You can see.
Yes, now you can admit me, Paul. At least they won't swallow me. I can tell them to go to Facebook.
Wendy, you can admit people.
Yeah.
You are a co-host.
Fine.
Malaka, you'll be sharing the screen or I share it?
You have the rights.
I've admitted
to share the screen, so I'll just unmute, stop my video, and allow you to show people things that matter.
All right.
So you can start the presentation.
We'd like for everyone to be admitted.
Good afternoon, everyone. My name is Wendy Muganda. I'm the programs manager at LSK Nairobi branch. Thank you all for attending this session. Just for housekeeping, let's try and have our microphones on mute unless when necessary. If anyone needs to ask a question, kindly you can raise your hand or type in the chat section. I'll be monitoring the comments that are coming in. So I will just invite the Nairobi branch chair when he's ready. I can see he's already here to just give a few opening remarks. And thank you all for keeping time. Before the chair gives opening remarks, I would just like to say that this is an initiative of LSK Nairobi branch, and we are glad that we're in partnership with ICS and BRS. However, the BRS staff could not attend this session. but because we're in liaison with them and we have a technical subcommittee meeting, we'll forward your concerns and share an email address where you can send your queries, comments, and proposals. So I will just allow Mr. Eric Theuri to give his opening remarks. Chair, karibu.
Asante Wendy. Thank you and good afternoon, everyone. Happy New Year to most of you. We want to welcome you to this webinar. We have been receiving quite a number of inquiries with regards to the question of beneficial ownership. And that is the reason why we organized this forum for purposes of sharing on some of the challenges that the members have had as they try to update their records at the company registry. We are hoping that most of you have had an opportunity to go on the survey and give us feedback on any of the challenges which you may have experienced as you go through this process. So we are hoping that at the end of it, we should be able to collect all the feedback that has come in and also the feedback that is going to come in today with a view of seeing what we can do to address those challenges at once the technical subcommittee retreats to have its discussions. And so for that reason, we just want to take this opportunity to welcome you. Thanks for keeping time. I can see that we have over 100 participants, so that we are able to maximize the time that is available to us. I just want to take this opportunity to welcome all of you. Thank ITS for the collaboration and BRS for the collaborations that we've had over the last 1 year between the branch and the various teams. So you can rest assured that whatever concerns you have, which you raise either through the survey or through the discussions here today, would be taken seriously. And we would be, after this forum, be looking at all those issues and trying to find a way of addressing them. Of course, I know there's been challenges with downtime. There have been challenges with the older companies. We have challenges with companies that are either going through succession or those that are have disputes in court over directorship. But I think that for as long as we are talking and for as long as those concerns are being expressed, then we would find a way to deal with the issues that are arising thereof. So thank you everyone for joining us. Wendy, I think we can now introduce the speakers so that we can start. I see we have a good quorum. Thank you everyone for coming.
Thank you, Chair. I'll just invite one of our speakers, Ms. Sally. You can take the lead from here.
All right, thank you, Wendy. Good afternoon, everyone. My name is Sally Kamau. I'm an advocate practicing at Shitiva Advocates, LLP. And I'll take this opportunity to thank everyone who's joined us for this webinar. And we'll proceed to discuss this new development of beneficial ownership. I know most of you in the legal fraternity have had clients asking about it. Most of you have managed to be able to update the beneficial ownership requirements. Some have had challenges. And so I'll make a brief presentation on the requirements of the law and what it entails. Then afterwards, I'll open up the session to the rest of the panel members who have joined me. I'm joined by Mr. Malakai Adede. also joined by Ms. Sylvia Kithinji, Mr. Simon Karaoke, and also Ribin Ondwari. So without further ado, I'll share a screen to begin the presentation. Kindly forward your questions through the comment section so that we'll address them once we are done with the presentation. Alright, so we'll begin with in the background as to why the beneficial ownership requirements came about, and this was due to a recommendation by the financial FATF, Financial Action Task Force. And the reason why it came about is because there's a risk of legal persons and arrangements to facilitate criminal activities. As we know, there's so many legal persons that take advantage of the structure and the entity that is a legal person to conduct criminal activities, for example, financing terrorist activities, issues like money laundering. And so to be able to curb these issues, FATF made recommendations to countries worldwide to make for provisions for beneficial ownership disclosure, so that natural persons are not able to hide behind such legal persons, such as company, to be able to, act and fund such illegal criminal activities. And now for the need for transparency and disclosure of beneficial ownership, Kenya was one of the countries that took on this task, and through the changes of the Income Tax Act, which was amended in the year 2014, there was a requirement for all beneficial owners to be disclosed to the Commissioner of Tax, and this in the year 2017, the Companies Act Kenya made amendments as well. It's section 93A of the Companies Act was amended to be able to disclose and to require all companies to have a register of its beneficial owners, as well as refer these beneficial owners. Sorry, could we kindly all mute on our end? There's some background noise. Thank you. So in the year 2017, amendments were made to the Companies Act, specifically section 93A, to require all companies to disclose their beneficial owners and to also file with the Registrar of Companies a register of their beneficial owners. Now, when we look at the applicability of the beneficial ownership regulations, we see that it applies to both companies limited by shares and companies limited by guarantee. So all companies that are incorporated and registered in Kenya have the responsibility to comply with this new requirement. And companies limited by shares, it also includes private companies and public companies. Now, for the disclosure requirements and the thresholds for companies limited by shares and companies limited by guarantee, when you look at the table, on the side that talks about companies limited by shares, you'll see that the following thresholds that we've listed are required to be met for these people these natural persons to be, referred as beneficial owners. And just to take you slightly back, I'll give you the definition of a beneficial owner, so that once we get into these thresholds and the requirements, it will be a little bit more clearer. So a beneficial owner is defined as a natural person who ultimately owns or controls a legal person or arrangements, or the natural person on whose behalf a transaction is conducted, and includes those who exercise the ultimate effective control over a legal person or arrangement. This means that according to the requirements, all companies are required to look into who are the beneficial owners up to the last beneficial owner. It does not require that the person only holds shares. You might be a beneficial owner only for the reason that you exercise significant influence or control over the company. So for companies limited by shares, natural persons or individuals who have direct or indirect, who hold direct or indirect shares, 10% of the issued shares of the company are referred. One is individuals who exercise at least 10% of the voting rights in a company. Different classes of shares. You might have ordinary shares or preference shares, but one might have, the to as a natural person, as a beneficial owner, sorry for that. The next beneficial owner is referred to those who have rights to appoint or remove a director of a company. So one need not necessarily just hold shares in a company. If they have the right to appoint or remove a director in a company, for the reason of disclosure of beneficial owners, they are referred to as a beneficial owner. The last criteria is if one exercises a significant control or influence over a company. We know that there are various arrangements that especially complex entities that normally hold. For example, you might have a company that has one holding shares on behalf of another, or you might have one who is a nominee of another and acts on behalf of a beneficial owner. So companies are required to go up to the last beneficial owner and look at who is it who has a significant influence. Do they affect the day-to-day operations of a company? Do they, contribute significantly to the financials of a company? Do they control, influence a company in terms of trust arrangements where one might hold shares on behalf of them in trust? And if so, and if they control these natural persons, yes, then they are defined as beneficial owners. So companies limited by shares are slightly different, or they differ greatly depending on how you look at it from companies limited by guarantee. And as we know, companies limited by guarantee do not have shareholders per se, but have members, or they have both directors and members of the company. So for this purpose, companies are supposed to look inwards and look at the persons who they may consider to be beneficial owners. And the criteria they need to use is who directly or indirectly exercises at least 10% of voting rights in that company. The second criteria is looking at who directly or indirectly has the right or power to appoint or remove directors. So in this sense, there's a sort of similarity with companies limited by shares and companies limited by guarantee in that aspect. And finally, companies limited by guarantee should look at who directly or indirectly has a right to exercise or actually exercise significant influence or ultimate control over the company, or the directors or the management of the company. So this is also slightly similar to companies limited by shares, where companies are supposed to look inwards and establish, in as much as an individual is not a member or a director, do they affect the day-to-day operations? Do the decisions that they make, do they have control or direct influence over the directors or the management of the company, or even the financial decisions that are made? If a company is not able to make any financial decisions to move forward, without the go-ahead of this individual, then for all intents and purposes, this individual is a beneficial owner. Now, we know that there are structures that are legally registered, and some of them are quite complex. For example, arrangements such as trusts, where you have a trustee and a beneficiary, where one holds shares or any kind of property on behalf of a beneficiary. Now, when it comes to trust arrangements, you need to look at who is a settlor, who is a trustee, and who is this trust being registered in benefit of. So, for example, a settlor is a person who contributes or gives a particular substance or a particular structure on behalf of or for the benefit of a beneficiary. So a trustee holds this property. A settlor is a person who provides the property. A trustee holds this property on behalf of a beneficiary. So when you're looking at a trust relationship or a trust arrangement, a settlor, a trustee, and a beneficiary, or any class of beneficiaries, are all referred to as beneficial owners. Also, for trust relationships, you might have individuals who also exercise the ultimate control over a trust, who are not necessarily the settlers or the trustees or beneficiaries. These people are also referred to as the beneficial owners. And in the next slide, I'll give an example so that it's a little bit more clearer. So if you look at this structure that is provided here, that had also been provided by BRS, and I thought it was a good example that we could use, is this OPK Limited. It is owned by, in trust, there's a trust that is formed that owns 100% shares in OPK Limited. This trust that is registered, or rather this trust that is formed, is beneficial. It has beneficiaries ABC Limited, beneficiary D, trustee C, and settlor Mr. J. Settlor Mr. J is also referred to as a beneficial owner when OPK is concerned, as well as the trustee C and the beneficiary D, beneficiary ABC Limited. Beneficiary ABC Limited, the company, is owned 100% by Mr. E. So once you look at this structure, you'll have to go downwards up to OPK Limited, which is here at the bottom, and look who are the people who stand to benefit and who make direct decisions with regards to OPK Limited here at the bottom. Now, with regards to this presentation in this diagram, you'll see that OPK Limited cannot function without the trust that is on top of it. And this trust that is on top of it is mainly formed on behalf of the beneficiaries and the settlor and the trustee, all these who make decisions in the trust. That is, all right, let me expand the font so that it's visible to everyone. Okay, I'll just proceed. In case there are any questions, we'll answer them at the end. And so the trust that is formed here, we know it really will not have existed if there was no settlor, trustee C, beneficiary D, and beneficiary ABC Limited. And this trust being 100% owner of OPK Limited. Now, when the question arises who the beneficial owners are, it will be all these parties, including individual Mr. E at the top, because all the decisions that are made from the top all the way to the bottom affects the day-to-day operations of OPK Limited. Therefore, the settlor, the trustee, the beneficiaries, and the individual at the top who owns shares, 100% shares in the beneficiary ABC Limited, are all referred to as the beneficial owners. Now, as we know, for reasons of compliance requirements, we know that the deadline for registering and adhering to the beneficial ownership declaration requirement is 31st January 2021. Companies are required to notify all the persons that they believe they have reasonable cause to believe are beneficial owners. And the regulations have provided that individuals should be given 21-day notices. I know this is a little bit late considering that the deadline is 31st January 2021, but I believe there's a slight time allowance where beneficial owners are required to provide for the particulars of their beneficial ownership. Now, the particulars that are required by the registry with regards to disclosure of beneficial ownership requirements are the usual requirements such as email addresses, phone contact number, residential address. Also, the registry also wants to know what kind of influence does this individual have. Do they have 100% share ownership? Do they have 100% ownership, voting rights? Do they have direct or indirect control over the company? And information also including the residential and the type of businesses that they do, including are they an entrepreneur? Are they a lawyer? What kind of profession are they involved in? Now, unlawful disclosure of beneficial ownership attracts a fine not exceeding 20,000 or imprisonment for a period not exceeding 6 months. We know that there are companies who perhaps the law might have caught up with them and they might not want to disclose all the beneficial owners of a company. Now, as the legal fraternity, I think it's our role and our responsibility to also advise our clients what penalties that they'll be looking at if they provide, unlawful information or provide unlawful disclosure of this information. And failure to provide and maintain a register of beneficial owners exposes a company and its officers to a fine of 500,000 on conviction. This means that past, the deadline of 31st, a company or its officers might face that challenge moving forward. So it's important for us to also advise our clients accordingly. For companies that have beneficial owners who, are reluctant to provide their beneficial ownership information, they have the mandate to issue warning notices to such individuals. And according to the regulations, the warning notices are supposed to be a 14-day warning notice. If at all, such individuals, upon being given warning notices to be able to disclose their information, if at all they do not give such information, then companies also have the right to restrict rights of non-compliant members. So for example, if one had a certain percentage of voting rights, such rights might be restricted. Individuals who are non-compliant. If at all there are any restrictions that are awarded to a member due to non-compliance, then the same should be registered with the company's registry within 14 days of that non-compliance. There's something else perhaps I should mention that is important is when you look at the distinction, and once you go on the eCitizen portal, we know sometimes the law might go ahead of the eCitizen portal and the infrastructure that is in place. Because perhaps for some of you from your experience, you've managed to update your beneficial ownership register or on behalf of your clients, specifically for companies that are private limited companies, limited by shares. However, for those who have tried to update their beneficial ownership register for companies limited by guarantee, there's a slight challenge to that. I know once you go on eCitizen, it mentions that it's not applicable. However, it might be an infrastructure issue that is yet to be updated. So kindly still advise your clients to provide that information and to investigate who their beneficial owners are, because once the portal is ready to go and ready to accommodate that information from companies limited by guarantee, then they'll be required to provide such information. Also, I know for public companies, public listed companies, they are not also able to do that as per the eCitizen portal. However, I know that is also an infrastructure issue as far as I've been informed, but that should also be checked in quite soon. So that was my brief presentation, and now I'll welcome questions. It will be an interactive session, and I'll be joined by my panel members to answer any questions that arise. Thank you very much.
Thank you, Sally. I'd propose anyone who has a question to just kindly raise their hand so that the panelists can see from their end, and they can answer some of your queries. However, as I had mentioned before, the BRS staff are quite occupied right now. Unfortunately, they could not join us for this meeting. But if there's any question that is beyond the panelists' control, then we will forward your concerns to BRS. I will share an email address where you can send your concerns. So I think we can now start taking questions. I can see Ms. Joanne's hand is up. Malachi, Sylvia, Sally, Ribin, Simon, you can start taking the questions.
Thank you, Wendy. My name is Malachi Adede, member of...
Sorry, Malachi, to interrupt. Kindly, if you have a question, raise your hand. Then after your question is answered, kindly put down your hand, because the chats are so many, we might skip one question, and we don't want you to feel that you are left out of this session. Malachi, you can proceed.
Thank you, Wendy. I think for starters, there are a few questions that we are seeing on the chart that they relate to what BRS does, but out of the practice and what we've experienced, we can actually share experience on how this should be attended to. So there is an interesting scenario on companies that have partly issued shares, that have unissued shares. The system takes into consideration both the issued and the unissued shares in coming up with the percentage that any one shareholder holds. In practice, what we've been doing is on the part of ownership, we put what the system has calculated, but then we go back and calculate using only issued shares, the portion, the stake that that shareholder has, and we put that under voting. If it is more than 10%, then that will trigger their qualification as a beneficial owner. So the numbers then you enter in the system are different in that respect. It is important to understand the difference between direct interest and indirect interest. We have 4 criteria, and each of those criteria, there is a direct aspect to it, and there is indirect aspect to it. The direct stake is where the shareholder in the register is the one who exercises that right or meets that criteria. Where it is indirect, it means that the shareholder in the register is either a nominee shareholder, which means there is a principal behind them who then becomes the BO, or the shareholder is a corporate entity, where now we go behind that corporate entity to identify the individuals who meet the criteria set in the regulations. So that distinction is important to note. There are members, sure, go ahead.
Yeah, maybe on that same one, I think it's important to mention that on the system at the moment, if you indicate that a shareholder is a direct shareholder, then it will not be possible for you to add a beneficial owner. So if you go onto the portal and you say that Simon holds these shares in his own behalf, so if I have 10% shareholding and you say that that is direct, then you will not be able to appoint a BO behind me. And this is affecting largely corporate entities. So where you have a corporate entity as a shareholder, please be careful to note that you do not put any shareholding as direct ownership. Because if the corporate owns 100% and you put 100% as direct ownership, then you will not be able to add a BO. However, if the ownership is 100 and the direct ownership, you put 0, then when you appoint a BO, you will be able to actually put the indirect owner of the shares. Malachi, back to you. Malaka, you need to unmute.
This is a test company that we can use for purposes of demonstration on what happens in the system. We have an individual, this non-existent individual, and this non-existent company being shareholders in this non-existent client. So for demonstration purposes. Now, for individuals, when you come to update BO, the system calculates for you the percentage that is held in the system. Then you have to disclose which of this percentage is held by the client. And that's where you put direct in stake. If you put 0 here, it means this 40% is in its entirety is held indirectly. So then the system will require you to appoint a beneficial owner. You can put 20, but you can't put more than 40%. Now, when you put 40% and you add this, the system asks you to put the date when this individual became a beneficial owner, which for purposes of all old companies, we do select the date when the regulations were gazetted, which was 21st February 2020. That is the effective date. That's the start date for all BO effective dates. Now, if you select someone to be direct shareholder, the system picks the information for this person that is in the system. So if the system does not have telephone number, if the system does not have email address, if the system does not have their residential address, or the system will, the form will come without that information. So those are the cases where you find that you know the information, but you cannot amend the form to reflect the complete information. The solution is to first update the particulars of the shareholder, which now we do not have a prescribed form, before then you proceed. As far as the company is concerned, if you update the company, the rule of thumb is all the shares being held by the company are being held indirectly, because the regulations require you to input the details of an individual. So by you putting in the system that this company's share are held directly, the system is configured now to let you proceed, but you would have not provided all the information provided in the system. So that should address the issue of direct shareholding, indirect shareholding, and forms that do not reflect the information that you know should be reflected, and yet you cannot amend that information in the system. Now, I needed
one point, Malachi. I hope guys can hear me. The effective date is the date that the person actually became a BO. So we have said for the companies that were registered before the 21st of February 2020, then the effective date of such a person becoming a BO is the date of 21st February 2020, which is the date when the regulations were gazetted. However, for companies that were incorporated after that date, it's the date on which such a person became a BO.
I believe that's clear enough.
So I'll just mention a few hands which are up. There's user 9, Joanne. Joanne raised her hand up first. I think we can hear Joanne. Then go to Irene, Vaishali, Shell, Jimmy Simiu, Michelle, reception. I think we can take that order. And please, after you're done, please lower your hand.
Okay, thank you so much. Thank you for the detailed presentation. My question would be, in terms of when you're advising your clients, what are some of the implications of actually being named a beneficial owner? What are some of the risks? What are some of the benefits? Does it mean that then the beneficial owner and the company become one? Because before, the company was, for example, separate from individuals. It was a legal entity on its own. So maybe just highlighting some of the risks and benefits of beneficial owners. Thank you.
Good evening, good afternoon, colleagues. This is Irene Kiwal. I have several questions with respect to the interactions with the system. But before that, I would seek a clarification, and unfortunately, there's no one from the BRS. My question is with respect to data protection. The onus under the regulation has been imposed on the directors of the persons disclosing, but being Kenya as it is, what can the registrar confirm this information that we are disclosing, particularly because of the concept of nominee shareholders and directors and proxies, will actually be confidential? Should we also be seeking indemnity from the registrars in the event that any of this information becomes disclosed with respect to this beneficial ownership that has come into place? Now, with respect to the system, Malachi was taking us through, and I was really hoping to see how he will finalize when we're dealing with indirect ownership. Because with me, and I'm wondering, is there somewhere I'm not clicking? Because when I have indirect shareholding, like the first slide that you were giving us with respect to 40% as total percentage, and then the direct ownership, when I put 0, the system, when I say continue and proceed, it rejects me from proceeding by saying that I must update the beneficial ownership and declare, and I'm like, where? Because I'm not seeing it in the system. So I would like to see where we update that information so that because I cannot allocate, because my client is 100% indirectly holding those shares. So if I'm forced now to indicate 0.1% or 10%, I'm actually giving misrepresentation. So I would like to see how that is being done in the system.
Wendy, can we address this first? Because we have, I think I've seen, this is the third question on the same topic on where to allocate the indirect shares.
Yes, please.
Okay, so back to the same screen. So let's say, for instance, we say that the direct holding for this shareholder is 0, and then 40, then the indirect voting is also is 0. Now, when we just proceed in that one. So when you complete, so the process I was doing was allocation of beneficial interest in the company.
Yes.
You indicate whether it is direct or indirect. So once you've allocated, then it gives you a summary below on where those shares lie. Now, to proceed from here, you need to appoint a beneficial owner, and you click the Appoint tab. I'm hearing echoes of myself. I don't know if it's from here.
Please mute your microphone.
Mute your mics. Yes, mute your mic.
You click appointment. So if you have a long form, please scroll to the bottom. If I click save and continue, I will get the error message because I have indirect shareholding for this term here, which have not been allocated. So to allocate those and the system to allow me to proceed, I click appoint. Under ID type, you select beneficial owner. You select the right ID type. For this purpose, I'll choose foreigner. You put all the information which you have. Then at the bottom, there is the allocation of indirect shares, which you click add, you select the shareholder, it will tell you how many shares are available to allocate. Now, if I say 40%, it's fully allocated. And then I come to indirect voting rights. Again, you select that person who had indirect shares, then you allocate. Once you've done that, you put the dates and the other information and you submit. Now, if you do not appoint someone here, the system will not allow you to continue. So it is this step of adding who exactly is holding those shares directly that will stop you from proceeding. I trust this clarifies on how to add an indirect beneficial owner. Now, this is also how you add beneficial owners behind the company. Once you've indicated that the company is holding those shares indirectly, as Simon rightfully pointed earlier on, you can add as many people here as you have shareholders to whom this person is holding shares indirectly. And then if you add, you can also remove this if there are more. So if the other company, this company was also, you see, when I select this company, it tells me max is 0 because I have not allocated those indirect shares. So for me to capture the company, I have to come back here on allocation and say that this company is holding these shares indirectly. And then I can put, for example, so the system I'm using now is a little bit behind the live system that you're using. So I'm not able to clearly allocate all the shares. But if you are to put 0 under the system, it will give you the indirect holding. So for demonstration purposes, let me do this. Let's see if it will bring the allocation. Then when it comes here as one of the companies, you come to allocation, select beneficial owner, complete all the information. When you come to shareholding, you have the company. Now you can allocate the 60 shares, 60% of the shares that the company is holding. Now, if there are many individuals behind this company, so let's say this was Jane Doe. Once Jane Doe has taken 20 of this company, the next person, you can't allocate the company twice to Jane Doe. So when you appoint the next person, you will find that the balance here is 40. Then you allocate until this comes back to 0. You would have finished your allocation process for the indirect shares. I trust that explains how to go about indirect shareholding.
Okay, thank you, Malachi. I think, Irene, you can lower your hand. Next, we have Vaishali and
I still
Joanne.
have questions.
Okay, I think
questions before we move to the next round.
I think, to be fair to everyone, we can restrict the questions to 1 or 2, because I'm seeing we have 384 people. We need to answer as many questions as we can in this session alone. So
I think you can also address Joanne's question. She had raised a question before.
Wendy, sorry to take you back. I just wanted to clarify something also from Irene's question regarding, confidentiality and also protection of the data that will be provided to the registrar. When you look at the regulations, it provides for instances, very strict instances, when such information should be, put out and disclosed. So, for example, the regulations provide that for companies, they'll only provide this information for purposes of being in strict compliance with the disclosure of beneficial owners. And the registrar, in the office of the registrar, this information, according to the regulation, should not be made available to the public. And the only specific instances that the Act has provided, that it will be disclosed in relation to if they receive a written request from a competent authority. And when you look at the definition of a competent authority, they've provided that if they have a request from either courts, the Attorney General, any criminal investigation agency, or a law enforcement agency, or the Kenya Revenue Authority. So it's very specific instances that the regulations are provided where this information can be put out to the public, so to speak. Also, a company, for purposes of the Data Protection Act, and the registrar will now fall within the definition of a data processor and a data controller. That means that they'll strictly also have to adhere with the provisions of the Data Protection Act for purposes of protecting this information of beneficial owners. Wendy, sir, you can proceed.
Thank you, Sally. And to respond to the question that Joanne asked on when you are advising your client how to advise them on the impact of disclosing the BO particulars, the BO disclosure is pursuant to Section 93A of the Act. So this is a compliance requirement under the Companies Act. And as far as we know, compliance is non-negotiable. So either you comply or you choose to deliberately not comply. Now, the beneficial ownership information by no chance do not lift the corporate veil. The corporate veil does not relate to knowing or not knowing who the ultimate beneficial owner is, but is on the limited liability principle that shareholders enjoys in the company. So as far as our discussions as practitioners with our clients go, is that this is any compliance similar to preparing the register of members or register of directors or filing an annual return as prescribed under the Act.
Hello? Hello? Yes, it is.
Just to add to what Malaka is saying, additional things that you should consider, Joanne, as you advise your clients, is that obviously from a practical perspective, there'll be certain implications. For instance, if there were nominee sort of structures for purposes of privacy for one reason or another, then in that respect, and as far as directors of the company or officials of the company, as well as the registrar, would have that information, of course, subject to, confidentiality provisions within the regulations. But beyond that as well, we also know that there have been structures that have been put in place to sort of circumvent sector-specific regulations and especially those that relate to local content. So where you have structures that are, put in place in order to circumvent, compliance obligations, then your client would definitely have a big problem over there, because the beneficial ownership regulations, I mean, as Sally said, as she began, is a step towards enhancing transparency and creating a level of transparency that would be able to unearth all these sort of compliance workarounds. Thank you. Wendy, you can take it from there.
Thank you. Let's have Vaishal and share their questions. Then after that, we have Kathy and Jimmy. Vaishal?
Maybe as we wait for Vaishali to ask her question, I think she's dropped off. Couple of questions I've seen on the chat around which companies or which entities are supposed to comply. So all limited companies that are limited by shares or limited by guarantee are expected to comply. However, as Sally mentioned earlier, the portal for public companies, not just public listed, but public companies generally, and companies limited by guarantee has not been developed. However, foreign companies, or what we commonly refer to as foreign branches, are exempt and are not required to disclose details of their beneficial ownership. Chair, I think that you're next to ask your question.
Good afternoon, everyone. Thank you very much once again for the detailed presentation. My question is, I have a company with dormant directors, and am I supposed to add all of, all the directors, or can I resign, for example? Are there any legal implications of me resigning before the deadline, or can I proceed to do that? Thank you.
This question also relates to a question where I saw on the chat, someone was asking that their company has been dormant for more than 10 years. Do they need to comply with the BO regulations? There was also a question on if someone has started the process of deregistering their company, do they have to comply with the BO regulations? Now, the BO regulations compliance crystallized on 21st of February 2020. Now, any person who was a beneficial owner as of that date, whether you resigned in between or you've resigned now, or you are going to resign or transfer your shares next month, in the records of the company, you should have been recorded as a beneficial owner. Whether that person then provides information or not, that's not material in my interpretation of the Now, on a separate note, I have inquired with the registrar of companies where a company has been dormant for a while and you elect to strike off that company at this point, they will not require you to comply with BO, only if you are striking off that company. But in our Companies Act, a dormant company, whether it is a international company, or if it's a or a listed company, the compliance requirements of Section 93A apply uniformly to all the companies that have been mentioned by Simon and Sally earlier on. So it does not matter whether you're a small company or a big company, a dormant company, an active company, the compliance requirements under Section 93A applies to your company. A company that is in court and the ownership of the company is challenged, Regulation 11 of the BO regulations applies, the regulations allow you to indicate that you know that there is someone who meets, a shareholder who meets any of the 4 criteria. However, the identity of that person is a subject of court and is yet to be determined. So you can enter that statement in your register. Please do note that directors, in their capacity as directors, are not beneficial owners. One is a beneficial owner only if they meet any of the 4 criteria set out in the regulation, which is 10% shareholding, 10% voting, the unilateral right to appoint or remove a director, or a unilateral right that an individual exercises to influence or control a company. The key management, the CFO, CEO, COO, and those type of key management, and the board of directors, individual directors in their capacity as directors, should not be disclosed as beneficial owners. If you do that, then you need to show, you must have seen a document that vests any of the rights or any of the 4 criteria on that particular director. Otherwise, my rule of thumb is the directors are not beneficial owners in the first instance. Over to the team, Wendy.
Thank you. Let's have a question from
you had said Kathy?
Yes, Kathy. Share, you can lower down your hand.
Okay. So thank you for this. My question is that there are 2 companies I'm dealing with where the person who would have been a beneficial owner has recently passed on. In one case, and in both cases, they've not had time to go for probate. Now, in one, the beneficial owner is actually the settler. In the other, he's the actual owner of the shares, or he was. How do we indicate? Do we write their name down as BO and then in brackets write deceased, or how do we do it? I hope my question was clear.
The question is very clear. I want to request Simon to take this one, or Ruben. Simon?
Okay, thank you, Malachi, for throwing me onto this one. In the instance where a person is deceased and the probate process has not begun, I think it would be acceptable to actually put in the name of that person and note that they are deceased. Sorry, someone said my mic is too low. I hope you can hear me.
Now it's loud enough.
Yeah, so I'm saying in the instance where someone is deceased and the probate has not commenced, then it is okay to add that person as the BO, but to highlight that they are deceased. You might have a problem in the event their details have been taken down IPRS, but I don't think that would be the case.
Whoa, this must be the biggest.
I'm not very sure whether IPRS would have updated their details if they are recently deceased.
Simon, if I may, I think if the person died last month or in November or so, the BOF1 will go in with their name because that's with effect from 21st of February 2020. So for the duration that they were alive, they were beneficial owners. Then on their demise, you can then file the cessation from BOF3, I believe, Simon, and then put the evidence, maybe a copy of the death certificate as the support for their cessation. Because after that, after their death, then there should be a different set of individuals being appointed once the court process is completed. So my take will be for the duration that they were alive, between the BO regulations coming into force to the date when they died, they should go on record as the beneficial owners. Then after that, you can amend based on the recommendations that Simon is sharing.
Agreed. Agreed. All right. We can move to Jimmy Simiu and then Daisy.
Sorry, all. I'm here with my colleague Jimmy. My name is Faith, so I'll be taking the question on our behalf. And my question really just relates to the deadline. So there's a lot of frantic activity right now for everybody to comply by end of this month. And I'm just wondering what happens in the case of companies that are not able to comply by the deadline? What is the intention or what is the penalty? Because from where I sit, I don't think that this deadline is supported by either the Act or the regulations. So in terms of moving forward, I mean, what's the consequence of non-compliance? It's not really about whether they should comply or not. It's a question of what happens if somebody has not complied by Friday. And the other question that I'm wondering about is relates to how the system has been set up to deal with beneficial ownership information of a corporate entity. I realize that the system sort of accepts or expects one to enter the name of another company, like a topco, as the beneficial owner, which entirely beats the purpose because the idea is to get natural persons as the beneficial owners. So I don't know if anybody has interacted with any of these issues and is able to comment. Thank you.
All right. Malaka, you want to take that? All right.
I just wanted to deflect a section of that question. When we started, we did mention that we are here as fellow practitioners to vent over matters that affect us practitioners. The registry is not here. We cannot speak for what the registry can, will, or are to do. We do know that the notice period was 3 months, starting sometime last year, ending this month. What the registrar will do or will not do at the expiry of that notice period, we can only wait and see. I don't know if there is any different approach to that, Tribin, you're aware of, as far as the deadline goes.
Not specifically speaking for the registry, but as we all know as practitioners, I mean, this is a requirement that has already crystallized in law by virtue of the enactment of Section 93A and the prescribing of the regulations, which Malachi has correctly quoted the date. So technically, by virtue of the interpretation of the law, even before that deadline, this information ought to have been published and provided for as soon as the regulations were published. But in any event, these penalties and fines which have been prescribed under Section 93 do not just accrue automatically. There has to be a conviction of an offense on that particular aspect. So this then shows the reason why the registry was then empowered to take the administrative action to set out that 3-month deadline within which to give people the leeway to file this information. But then going forward, the fines legally cannot accrue automatically, but this would have to be upon an actual taking up of a case, and this case being sustained in court and a conviction actually sustained. So to that extent, then it would actually still remain within the discretion of the company's registry as to which instances then they'd want to take up and pursue as a conviction. And as we all, I mean, from the practical aspect, so far we haven't seen any such action being taken because they're taking the rather collaborative approach to try and get everyone to comply before taking the conviction approach. So from my interpretation of the law and at least previous engagement with the registry, that's the extent to which I would then respond to that particular question.
Okay. Now, having addressed the first part of Faith's question, going to the second part, I'll share again my screen. The regulations are clear. and indeed section 93A is also clear. The BO disclosure relates to individuals who ultimately meet any of the four criteria set out in the regulations. Now, when you start the process at incorporation or for existing companies, when you are updating this, there are instances where if you say the company holds those any of those rights directly, then the details of this company will then appear in the form BOF1. So the information you as a user, you input in the system is what the system pushes for you in the form BOF1. So all practitioners should note that for companies, all companies, the ownership or voting rights are all held indirectly. And when you come to appointment, where now you put the individuals who holds those shares, the system only gives you three options: either a Kenyan citizen, a foreign resident, or a foreigner, who are all individuals. So if your form BOF shows a corporate entity, then you as the system user is the one who has input the wrong information, which then the system has pushed back to you. So as far as BO disclosure is goes, you are required to provide details of natural persons. We can go to the next question.
Michelle?
Thank you. Michelle here. I have a question. So I've been trying to file a BO for for a client, but when I go to the place where you're supposed to update the BO, some of the companies that are shareholders have been replicated up to 3 times. So I literally can't file anything because say I file for company A, which appears twice. It then limits the amount of shareholding that I can put for the other companies. So I'm stuck with around 4 or 5 companies where I can't update the BO because I have already updated the BO, and then which means I can't move forward and I'm stuck. That's it.
If the company information is incorrect, I think the first step you should do is to have that corrected. There are companies that during linking different erroneous information was captured, some shareholders appearing twice. It's upon you to flag that with the registry staff for them to link the company to the correct position. As long as the information is wrong, you cannot then effectively comply with the BO disclosure requirements because it does affect the percentages in the system.
So I actually tried that, and from their side, they seem to see the system is okay, but from my side, the system is not okay. So I keep on calling, and they keep on telling me there's no problem with the system. From their side, they can only see one company appearing, but from my side, I see some appearing 2 or 3 times. So I'm stuck.
Michelle, have you tried applying for a CR12?
Yes, the CR12 comes out properly with each company appearing as one company, not replicated.
Okay, because that's weird.
Very weird. I think what we can do on this, Wendy, we can take this on a sidebar. The next time we are collating issues from practitioners, we can escalate this to be looked into.
In the meantime, though, it may be best
I'm actually, Simon, I'm actually aware and I have seen a similar case to what is just being described now. So it's actually happening. The CR12 shows 1, but on the live environment, the entries are twice.
Ribbon?
I was just saying, in the meantime, it may be prudent for the affected persons to just make a formal communication of this to the registry, so that if at any time someone wants to take up charges on this, then there could be a formal documentation that this was the challenge and it was communicated within time.
Absolutely.
Thank you.
Michelle, you can lower your hand. We can have Daisy, Daisy Klexkani, then Batia.
Good afternoon. Thank you so much for this informative session. Simon had mentioned, I think it was Simon, he had mentioned an issue regarding the informing the registry in matters. For instance, I'm dealing with a company where we cannot link the company. We have been trying to link the company for the past few months, and we can't link it on account of there is a matter in court regarding a director shareholder. So now we can't link the company, and second, because of that, we can't update the BO details. In such instances, when you say a communication, since we can't access the eCitizen, does that mean we write a letter to the registrar informing them of our challenges of such instances? And secondly, in other companies where you see we have tried to link the company and it's still under review. This is another company and it's still under review. In such instances, will they still be liable for the penalties under the regulations?
Ruben?
On the first question, I mean, as a country, we are still in the letter writing format. So it would be prudent to just put that in formal writing and have it delivered to the register of companies to just cover yourself, because legally that obligation has already accrued. And then so it really would befall upon you to show that you took sufficient steps and even notify the registry as to the challenges which you are facing, because at the end of the day, it's them who would then recommend a prosecution and a subsequent conviction on this. So in terms of reasonability of approaching the process, it might be best and prudent to just write and inform that situation. The second question.
Okay.
Sorry, the second question was on?
If the application is still on linking review, so it's holding back your ability to comply, what then?
Yeah, I mean, I think same situation. As practitioners, at the end of the day, we have to take the prudent and practical position, because legally the obligation has accrued, but then practically that you're not able to proceed with this. So in my own view as a practitioner, the safest position to take to then cover your client's interest would be to notify this to the registry as soon as possible, again, in a formal writing that can be traced, so as to avoid a scenario where an issue of maybe a prosecution is being instituted without them knowing that this was the challenge that you're facing. That conversation would go much better where you've already taken the prudent steps of just notifying them, so that perhaps if it's something that can then be resolved, it's resolved. But on the second second issue, the issue of linking having been something which has been discussed for a very long time, it might also be prudent to follow up the other measures, perhaps through the branch or directly with the registry, to try and see what is holding up this linking and try and take the additional measures which have been introduced to try and simplify and fast track these linking processes.
We have this meeting slotted in between 3 and 3:30. So I think we have about 13 minutes to go. Wendy, if I'm not wrong.
Yes, I would suggest for those whose questions have not been dealt with, please share your concerns to lsknairobi@gmail.com. I have just typed in the email address on the chat section, and we'll see what we can do and forward maybe to the registry. And if there are some that can be answered, then the panelists will give us responses and I will share with you on email. With 13 minutes left, there's so many questions. Wow.
When it suggested I go next, I just
yes,
have
yes.
one question.
Yeah, I had mentioned Klex and Batia. So
I have a question as well. Jacob Bombong.
Yes, I understand, but due to constraints of time, as I had indicated, I think you can share your concerns to lsknairobi@gmail.com. And for those who missed out on anything within the previous minutes of this session, we'll share the recording on our social media handles as well. So you can go, Klex.
So my question is on corporate shareholders who, when you go to the final person, perhaps they own 7% and do not meet the other criteria. So what do you need to do to make sure that you're still complying with this requirement from an e-citizen perspective? Because again, you still have to fill some information there.
This is the next item I was going to address. I've seen that question severally on the chat. Probably this will be of use to a lot of members. So can we address it before we go to Mbatia? Mbatia, would you feel harmed if we address this before your question?
No, go ahead. It's a common issue, please.
Okay. So I may want to mention that this is a feature available in the system that perchance was not intended to be so by the registry, but it does address the issue of when you want to, when you've taken all the reasonable steps and you've come out with no individual person who meets this threshold. This would apply for public companies with diverse shareholding, will apply for property management companies with more than 10 shareholders where everyone falls below 10 and no one meets the other criteria. So how you go about this, again, using my trial company, you come to maintain a company, you go to beneficial owners and create the application file. Once you've created the application file, you do not touch anything on this, on the update BO. You scroll right down to the bottom and click save and continue. Now, what this does, it recognizes that there is no one who meets the criteria set under the act. This only works where at least one of the shareholders, you have a corporate shareholder who has 10%, but behind that corporate shareholder, there's no one who meets the criteria. Then you click, you confirm that statement, and then you submit. Now, in my experience, the registry then sends you a correction request that you did not attach your Form BOF1. Then when you go to the correction bit, the correction now has an optional comment section. In that comment section, then you respond to the registry and tell them that you've reviewed the details of the company and you've not identified any natural person who meets the criteria set under the Act. I have processed a few applications in that manner, and they have gone through and they have been approved. Now, the other option of going through this, if you have 11 or more shareholders, you update the details of the BOs for every individual, assuming this was 4%, and then they also under voting is also 4%, and then under type of control, you select none, type right to appoint directors, you select 9. If you submit this application where the person has not met any of the 4 criteria set in there, the system will ignore that person. So whether there are 10, 20, 30 people, updating in this manner will yield no form at the end of the process. And perchance the registry will again ask you to attach a form. The same comment would be appropriate for that particular application. So those are two ways that you can address applications that do not have a beneficial owner who is reportable, pretty much. Someone who meets any of the four set criteria.
And Malachi, I think just to mention that this applies largely also for management companies. I've seen a lot of questions on the chat around management companies. So if you have management companies, that's how you go about it.
Management companies that have more than 10 apartment owners. If
Exactly,
it's the developer with 2 shareholders, then that's 50-50. You have to disclose the developer in the first instance as the beneficial owner until the reversionary interest is done.
Yeah, I think we should start closing. Wendy.
We had agreed to take Mbatia's question as the last question, and any other questions should be forwarded to the email in the chat section. So Mbatia, please raise your question.
Thank you for the presentation. It was quite helpful. We have a scenario whereby the ultimate beneficial owner of our client is a government entity, a foreign government department. Can think of them as a state corporation. How would you propose that we handle that?
Simon, do I have to call you out?
I can call out Ribbon. I think it's a good question, and we also have quite a few, including state corporations and national governments. It's where the BO is an office rather than a person. So I think for the purposes of I think again it's a case by case basis. What I would advise is that you again, like Ribin was saying, put it in writing to the registrar, because the guidelines are also not clear on this. Put it in writing and say that in your investigation or in your looking through the company's records, you have learned that the ultimate beneficial owner is then a state corporation or a nation, and that you'd need guidance on who to disclose as the BO. So I don't have a straightforward answer whether if you discover that the ultimate beneficial owner is the United States government, whether you can list Joe Biden. I can't really answer in the affirmative, but I think it would be good to just get ideas. Malachi, Ribin, what would you add?
We have discussed this at length with the developer and with Joyce, the registrar, at a forum. There are companies that, even though they are majority share, they do have majority shareholding usually. But if you do your due diligence, you end up with no individual behind those entities. So the recommendation we had passed at the last meeting we had was that the system be enabled for such reasons to be provided in the system, and in the process, ignore the shareholding of that entity. For example, if National Treasury, the CS of National Treasury is the shareholder, you can then select that box to ignore that shareholding and provide that this is ultimately the people of Kenya holding the shares, and there's no one who really meet any of the 4 criteria set. So I am not sure what version 2 of the platform as should be updated will look like, but we would see some of this going in and you being able, for example, where it's a public company owning majority shares, indicating such information in the system, and then the system stops requiring you to provide individuals behind that shareholding. So it's also good to note that the BRS portal, the BO e-register portal is still works in progress. It's not final in its current status, and we do expect that as we move along, it will be iterated to take in some of the comments that have been shared over time. I don't know if you have further comments on to this, Ruben.
Malak, I agree with you, and I also recall these discussions in respect to this particular type of shareholder ownership. And again, I'll just echo your comments that it appears to be, obviously it appears to be a work in progress, and for these situations where there are no clear answers, again it's just that situation of a prudent notifying this to the registry, and then so that if it's not among those issues which are being resolved in the second rollout, then as a practitioner, you've covered your client interests by ensuring that the registry is aware of the exact reason why this compliance is not happening.
And the same would apply where your client is say listed on a securities exchange, say in the United States, and it's not possible to get anyone that owns more than 10% shareholding in that listed entity. So again, exercise prudence, but then like Malaka is saying, we'll probably see such issues being addressed by version 2 of the system. Over to you, Wendy.
Thank you, Simon. Thank you, Malachi, Ribin, Sally, Sylvia, to all practitioners who set aside some time to join this session. For your comments, questions, feedback, I thank you all on behalf of LSK Nairobi Branch Secretariat. I will ask our chair to give final remarks so that we can close this session.
Wendy, thank you so much. This has been quite a lively engagement. You almost feel like we probably need to do another session and another session because there's been a lot of questions. Some of them have been answered. We still have one or two that look like they probably need more interrogation. So we want to, of course, thank all the members who've managed to join in. I think I would also want to express my appreciation to Sylvia, Wendy, of course, Malachi, Simon, Sally, Ribin, and everyone else for the really insightful presentations that have been given today. We would be taking stock of your comments, the chat, and some of the questions which have been asked and perhaps which need more clarification. And we would be consulting to try and see what would be the best way forward, especially on some of the questions that have come up with regards to linking that has not been done. Quite obviously, there appears to be a capacity issue or a lack of clarity on one or two issues. So we may want to look at that and try and see how best we can ensure that practitioners in these areas are able to give consistent advice to their clients and to be also to be of value to their clients. So we are grateful. You can take our assurance that we are going to take most of those issues that have been raised into account as we have our own discussions to try and see how to address some of these challenges. The presentation will also be shared in our social media platforms, our YouTube and Facebook pages, so we should be able to catch up on that. But I think of more importance are the issues which have come out and the very lively discussion that has been carried out today. So we want to thank everyone for their participation and to wish each and every one of you a pleasant evening. We would be communicating to you much later as we have our own side discussion and try and see how we can sort out some of the bottlenecks that have come out from this presentation. So thank you everyone for attending. Have a nice evening. Wendy, you want to finish off with anything else?
As mentioned, we'll share our recording. For those who have burning questions, send your questions to lsknairobi@gmail.com. Hopefully we can try and organize another session where BRS staff will be in attendance. So we'll try and engage further. Thank you all for attending.
Thank
Bye.
you.
Bye everyone, have a nice evening.
Bye everyone.
Bye, thank you.
Bye.
Bye. Bye. Thank you very much.
Bye.